namely Komal Chand and Dharamdas and Mohandas and others, relates to the specific performance of the contract and perpetual injunction which is being presented in the Honorable Court of Civil Judge Second Class. And the plaintiff's pleadings are: the suit property, that is the house, belongs to the first defendant named Dharamdas and his son, the second defendant Mohandas, by the virtue of registered sale deed dated 18 March 1980. The plaintiff Komal Chand entered into the sale agreement dated 5 July 1995 with the defendant for the purchase of suit property against a total sale consideration of Rs 50,000, and the entire sale consideration was paid to defendant by the plaintiff, and also the possession was handed over to the plaintiff by the defendant. The plaintiff submitted that the suit agreement executed by the defendant was meant for selling the suit property to the plaintiff. The recitals found in the said agreement itself would establish that it is meant for selling to the plaintiff. Sir, the defendant pleadings are: defendant taking the loan of Rs 50,000 in the year of 1991 as a security. The defendant has signed the promissory note in the favor of plaintiff, and the defendant incurred the loss because of the interest of 36%. So the defendant signed the blank stamp paper to the plaintiff, and the plaintiff informed the defendant about that he obtained out the in the form of security for the due payment. The plaintiff also informed that in respect of paying interest, he will have the possession of the suit property. A vendor who received the entire sale consideration is obliged to hand over the possession of the property to the purchaser and give the warranty for occupation free of disturbances. So the possession was given, but the defendant was not the illiterate person, that he had given the promissory note but not some of the documents of the sale deed. It is not possible to attribute any grave misconduct on the part of the plaintiff, especially in a case where the entire sale consideration has been paid, to deny him the relief of specific performance. On the other hand, it would be inequitable to deny such a relief in the view of Section 10 of Specific Relief Act 1963. The plaintiff, after paid the full amount of consideration to the defendant, when he obtained the receipt of the last payment, completes his part of the contract that has to be adjusted in the broader perspective. The plaintiff has been contacting and requesting the defendant to execute the sale deed, and defendant has promised to execute the sale deed within the 6 months. Then he avoided the execution since he was employed in Assam, and the cause of action arising when the defendant tried to alienate the suit property to the third party because the market value has been increased, and the plaintiff, already ready and willing to perform the contract, on 5th January 2009, the plaintiff sent the notice to the defendant for executing the sale deed, and then he filed a suit for a specific performance of the contract and the permanent injunction under Section 10 and Section 38 of the Specific Relief Act 1963 respectively. So the plaintiff come out with the clean hands and with a genuine case, so it cannot be alleged that he cannot come out with a genuine case. Sir, the admitted facts of the case are: firstly, the transaction of worth Rs 50,000 took place between the plaintiff and defendant. Second, plaintiff is in the possession to the suit property since 1995. Third, the defendant was the owner of the suit property since 1980. Fourth, the plaintiff also holds over the possession of the original sale deed of the suit property dated 1980. Sir, there are some evidences in support of my case. The oral evidences are: the plaintiff witness 2 and the plaintiff witness 3 are the attestors of Exhibit P1 agreement. The plaintiff witness 4 is the scribe of Exhibit P1 agreement. Some of the documentary evidences are: the Exhibit P1 is the sale agreement dated 5 July 1995. Exhibit P2 is the original sale dated 18 March 1980. So all these evidences prove that the suit agreement was meant for selling the suit property. Thank you.
The present suit, namely Komal Chand versus Dharamdas and Mohandas, is being presented in the Honorable Court of Civil Judge Second Class Chhatarpur, which was filed on 7 January 2009. The plaintiff's pleading in this case is as follows: Plaintiff mentioned that he bought the suit property, which originally belonged to first defendant Dharmdas, for the consideration of Rs 50,000. The amount was paid on the same day itself. Defendants transferred the possession of the plaintiff along with the original sale deed of the suit property dated 1980. Plaintiff, however, claims that even after requesting many times, defendant delayed the execution of sale deed. On 4 January 2009, he came to know about the defendant trying to alienate the property to the third party. On 5th January 2009, he sent a notice to the defendant which remained unserved. On 6 January 2009, defendant tried to interfere in plaintiff's possession in the suit property. On 7th January 2009, he finally filed this case of specific performance of the contract and perpetual injunction. The defendants pleading in this case are as follows. First defendant Dharmdas and his son second defendant Mohandas took loan worth Rs 50,000 from plaintiff on the interest rate of Rs 3 on every Rs 100 per month, which concludes to be 36% per annum in the year 1991. The defendants, however, incurred loss in their business and could not pay the interest to the plaintiff. Hence, they handed over the original documents pertaining to suit property to the plaintiff as security. The defendants had also given the signed blank stamp papers only as a security for due payment of the monthly interest. The plaintiff also informed that the defendant was that in respect of paying interest, he will have the possession of the suit property, and to that effect, he would write a document in the blank stamp paper obtained from the defendant. In July 1995, the defendant tried to dispose of the property for discharging the loan availed from the plaintiff. Immediately, plaintiff prevented the defendant from disposing of the property by using the blank stamp paper and getting the sale deed documented, prepared rather than a mortgage or loan agreement. Defendant were, however, ready to sell the property to the plaintiff already, but rather than the defendant when he tried to dispose of the property. Plaintiff hence filed this suit pleading a perpetual injunction against the defendant and specific performance of the contract under Section 38 and Section 10 of Specific Relief Act 1963 respectively. Admitted facts of this case are: first, transaction worth Rs 50,000 took place between plaintiff and defendants. Second, plaintiff is in possession to the suit property since 1995. Third, first defendant was the owner of suit property since 1980. Fourth, plaintiff also holds possession to original sale deed of the suit property dated 1980. After analyzing the argument presented by the counsel of plaintiff, we can conclude that these are the following questions which are to be addressed under this suit. First, whether the plaintiff should be granted perpetual injunction on the suit property under Section 38 of the Specific Relief Act 1963. Second, whether the said sale deed for the suit property be executed under Section 10 of Specific Relief Act 1963. Sir, here the plaintiff gave certain reasoning for his suit to be filed, to which I would like to address from the perspective of the defendant, which are as follows. First one is possession. As stated by the counsel of plaintiff, that the prayer of perpetual injunction is not time barred by limitation. The point to be contemplated here is the suit property was given as a security to the loan when the defendant incurred loss in their business. This makes the suit property a mortgage property, where the plaintiff or the mortgagee was in possession but the ownership right will still belong to the mortgagor, that is the first defendant. As for the fact that plaintiff considered the loan as a sale transaction and the loan amount as consideration to sale, the fact that the second defendant Mohandas holds no right on the suit property and including him in the sale agreement implies that the transfer of possession against Rs 50,000 was nothing but a security transaction against the said loan. Second is consideration. As the learned counsel of plaintiff mentioned that a vendor who had received the entire sale consideration is obliged to hand over possession of property to the purchaser and give warranty for occupation free of disturbance. But in this case, plaintiff already holds the possession of the said suit property since last 14 years, and as stated prior that the second defendant holds no right on the suit property and including him in the sale agreement clearly implies that the transfer of possession was already a security transaction. Also, the promissory note given by the defendant to pay the interest proves that if it was merely a security transaction to safeguard the loan amount and not a sale agreement. Now, as we take a look at the market value of house itself in 1980, and after adjusting the same with the rate of inflation, the value of property in the year 1995 was much more by many folds than the amount of consideration mentioned in the sale deed, that is rupees 50,000. This also indicates towards the possibility of the transaction being merely a loan and not actually the sale. Third one is clean hands. As stated by the learned counsel of plaintiff about the fact that plaintiff himself came to the court with clean hands, as the case presented by the plaintiff is genuine, but if we take a closer look on the timeline of the case itself, plaintiff took 14 years to file the suit. When the price of the property inflated this much, availing the suit property in such minimal price is itself a deal. The plaintiff hence filed this suit to gain ownership over the suit property in a way less amount of money than the actual value of the suit property itself. The intention of plaintiff itself seemed malicious in this scenario. Fourth is ready and willingness. The learned counsel of plaintiff stated that the cause of action arose on 4th January 2009 when plaintiff get to know about the defendant alienating the ownership to the third party, and the plaintiff was ready to execute the deed. But as we discussed earlier, the transfer of possession, holding over the original papers of the suit property and giving blank stamp papers all were merely a security transaction. Talking about willingness, even defendant is willing to sell the suit property to the plaintiff itself, but at the current market price and not at such a big loss. About the notice sent by plaintiff on 5th January 2009, the defendant never received the notice. Last but not the least is limitation. The counsel of plaintiff has mentioned about the limitation regarding the possession of the suit property, stating that plaintiff was in possession of the suit property from last 14 years without any restriction according to Article 65 of Limitation Act 1963, which is completely right. However, the suit property which is kept as security by the plaintiff, he can only keep the property in possession till the debt is not paid off. As to the limitation regarding thus relief, Article 54 of Limitation Act 1963 bars the specific performance of the contract after 3 years from the date fixed for the performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. Hence, the suit itself is time barred and worth being dismissed. Sir, I would like to put forth certain rulings regarding the same. First, K. Shanmugan versus C. Samayappan 2013, para 14. The said view expressed by the learned trial judge was rightly interfered with and held to be incorrect by the learned lower appellate judge. Of course, the first part of the observation made by the trial court, that limitation for filing a suit for specific performance shall be 3 years from the date of expiry of the period fixed in the agreement for performance shall be correct. Article 54 of the Limitation Act says that the limitation for filing a suit for specific performance shall be 3 years, and that the limitation shall start running from the date of expiry of the time, if any stipulated in the agreement. If no time is prescribed from the date or before which the sale transaction should be completed, then limitation for filing the suit for specific performance shall be 3 years from such date. If there is clause in the agreement prescribing a period within which the transaction is to be completed, then the limitation for filing a suit for specific performance shall start running from the expiry of the said period. Second, K. Venkat Rao versus Sankara Venkat Rao 1998. If there is another way or relief under the law other than perpetual injunction in such cases, the court cannot grant perpetual injunction. In this case, Honorable Supreme Court held that perpetual injunction is a court order to stop something. It cannot be ordered when there is an alternative way to solve the dispute. Sir, after looking at the following argument, we can see that plaintiff neither came with clean hands to the court nor came within the prescribed time limit and never explained the reason for the delay of 14 years. Also, he did breach the trust of defendant by drafting a sale deed instead of a loan agreement. Therefore, I kindly request this honorable court to dismiss the case with cost. Thank you.
As stated by the learned counsel of defendant about the possession and ownership rights, that it was a loan, so it is baseless. In fact, it is not a loan amount but a sale agreement. As stated by the learned counsel of defendant about the consideration, the plaintiff paid the full amount of consideration and the defendant given the payment receipt also to the plaintiff. As stated by the learned counsel of defendant about the clean hands, defendant is doing nothing but making and twisting all around the loan transaction. And as the learned counsel of defendant states about not receiving the notice, so here the first defendant given the reply of notice, which is marked as Exhibit P7 and Exhibit P8 dated on 24 January 2005 with the postal acknowledgement card also. So here are some documentary evidences which are Exhibit P3, which is the notice dated 5 January 2009, and Exhibit P6, office copy of the brief suit notice 20 January 2005. As the learned counsel of defendant stated about the time bar limitation of 14 years of not filing the suit, so in view of close relationship between the plaintiff and the defendant, he did not file the suit immediately. So it is not mentioned in the sale agreement about the limitation of filing the suit. And here the cause of action arises on 4 January 2009, where the plaintiff gets to know about the defendant that he alienated the suit property because the market value of the property increased, and also the defendant implied in the assam and he promised that he execute the sale deed in the 6 months and subsequently avoided the execution. Sir, all the defenses taken by the defendant are baseless and only twisting the things around the loan transaction and nothing. After analyzing the arguments of the counsel of the defendant, we can conclude that there are the following questions which are to be addressed. First, whether the plaintiff should be granted the perpetual injunction on the suit property under Section 38 of a Specific Relief Act 1963. Second, whether the said agreement for the suit property to be executed under Section 10 of a Specific Relief Act 1963. Sir, according to Section 38 of a Specific Relief Act 1963, the perpetual injunction may be granted to the plaintiff to prevent the defendant from breaching an obligation existing in his favor, whether expressly or by implied manner. The court will be guided by the rules and provisions contained in Chapter 2 of a Specific Relief Act 1963 when any obligation arises from the contract. The perpetual injunction can be granted to prevent the multiple judicial proceedings, to prevent defendant from invading the plaintiff's property rights when the defendant is in the plaintiff's trustee of the property. It would not be adequate relief when there is no standard for determining the actual damage caused by invasion. Section 10 of a Specific Relief Act 1963 deals with the cases in which the specific performance of the contract is enforceable, and it states to be enforced when there exists no standard as for ascertaining the actual damages caused by the non-performance of the act agreed to be done, or when the act agreed to be done is such that the compensation in money for its non-performance would not afford the adequate relief. So I would like to mention some of the rulings in support of my case. In His Holiness Acharya Swami Ganesh Dasji versus Sitaram Thapar, AII 1996, in this case the Supreme Court of India held that there is a distinction between readiness and willingness to perform the contract. Readiness means the capacity of the plaintiff to perform the contract, which his financial position to pay the purchase price, and for determining the willingness to perform his part of the contract of person to be properly scrutinized. Both the conditions are fulfilled in this case too. Another case is Nagar Palika Raj Singh Nagar versus Rameshwar Lal and another AII 2017. In this case, the Honorable Supreme Court of India highlighted the importance of 3 ingredients for grant of injunction. The 3 ingredients for the relief of injunction are the prima facie case, balance of convenience, irreparable injury if the prayer not granted. Thus, the plaintiff was able to prove all these ingredients. Thus, the plaintiff was rightly granted a perpetual injunction against the defendant in relation to the said suit. The court and the allegations made in the plaint, and from them come to the conclusion whether the necessary allegations have been made by the plaintiff in that regard or not. It is requested to the Honorable Court that a decree for a specific performance for the execution of the sale deed and the perpetual injunction for preventing the defendant from interfering the peaceful possession passed in favor of the plaintiff. Thank you.